former federal prosecutor Shan Wu, MSNBC contributor and former U.S. attorney and senior FBI official Chuck Rosenberg, and back with me is Charles Coleman as well. Kelly, let me just start with you, of course, because you're outside the White House there, and a lot of folks wondering how the White House is responding, if they're sifting through it themselves, the president as well, if he has anything to say.
Well, the White House, meaning the current Biden White House, and we want to, when we refer to the former president, I'm sure that gets confusing to viewers at sometimes, but President Biden has said that he is not involved in this. This is a matter for the Justice Department. Earlier in the week, he had said that he had had no advance warning that there would be a search at Mar-A-Lago. And today, when asked by one of our colleagues, a reporter in the pool, at an event for President Biden that was unrelated to any of this, at the end of the event, as we often do when we try to ask a question about the news of the day, the president was asked, do you believe there is any compromise to national security based on what has happened at Mar-A-Lago? And President Biden said, we'll let the Department of Justice determine that, and we'll see what happens. So that kind of question, which is one that has been raised by lawmakers. We've seen the Senate Intelligence Committee, which is evenly divided, Republicans and Democrats. Most committees are not split as evenly, but Intelligence always is. They have said that they want to have a review of a damage assessment, if you will, of materials that were at Mar-A-Lago, either those surrendered earlier in the process or those seized during the execution of the search warrant, and what was the possible risk to national security. Those questions have been asked by lawmakers. The Department of Justice has indicated that this is an active investigation, and typically that needs to operate in its own sphere and not have oversight while the investigation is going on. Clearly, the members of Congress have some oversight over what happens at the Department of Justice. So there's a lot of distancing that's happening in the Biden administration from the Department of Justice. There was a question you asked just a short time before the break about does anybody look in the boxes? Yeah. And so the General Services Administration is responsible for the transport of goods from a president who is leaving office to their home. What is interesting is they are simply putting together the truck and the order to ship it. It is the outgoing transition team that is required to do the packing of the boxes, the organizing of pallets, and to sign for those contents. And so the outgoing transition team, so people who are working for, in this case, Trump, would have signed that those goods that were being packed were necessary for the office of the former president or his personal belongings. And so that's how they determined that. The presumption is that you're not taking government records you're not entitled to. Yeah. And so there isn't a looking in each of the boxes based on the reporting I've been doing on this. But that is how it's done. And as you know, it's done on January 20th in a very hasty way with packing done in the days leading up to it. And for this particular former president, it was a particularly hasty circumstance because he didn't want to leave office and didn't think he would have to, not like the end of a two-term presidency when there's a lot of buildup and packing that goes on for a much longer period of time.
A lot of good information there, Kellyo. We thank you for filling us in on that. Actually, I want to pick up on one thing that Kelly just brought up. Chuck, if you could fill us in a little bit on the damage assessment. I know that hasn't yet been launched. Some of the conversations that we've been having on air with folks that know a bit about when a damage assessment is actually launched, there could be some sort of informal damage assessment happening as they're going through, sifting through some of the documents that they seized from Mar-A-Lago. But what is the justification for holding off on that?
Well, first, just take the notion of a damage assessment, Yasmin, outside of this political vortex. When we have highly classified information and we worry that it's been compromised in some way, intentionally, unintentionally, willfully, negligently, whatever it may be, it's incumbent on the intelligence community to try and figure out if any damage has been done. If damage has been done, what do we need to do to protect our sources and our methods and our assets? So this is, I don't want to say it's a routine thing because fortunately we don't have routine compromises of highly classified information. But when we do, or when we fear it, then we do a damage assessment. And so, look, I assume that this is just something that is reflexively done within the intelligence community. I've seen the results of these types of assessments when I was a federal prosecutor and when I was at the FBI. It's something that we take very seriously because we spend a lot of human capital and money in order to stand up these intelligence systems, signals intelligence, human intelligence, all sorts of ways in which we collect information to help protect the national security of the United States. So I assume it's being done. It is done when we believe there's been a compromise, and we have to think of it not as Republicans or Democrats or left or right, but outside of the political vortex as something we need to do to protect the national security interests of the United States.
All right, so here's what we're going to do, guys, with the three brilliant legal minds that I have on this panel. I first want to kind of talk about what is standing out to you amongst these 38 pages, a bit tongue-tied there. And then we're going to address what happens next. Right? A lot of folks watching this and saying, okay, what is going to come of all of this? So Chuck, let me just start with you and ask you that very question. What stood out to you?
Well, I was actually more interested in the memorandum that the government filed with the redacted affidavit than in the affidavit itself, because I wasn't terribly surprised that we didn't get the good stuff. And the stuff we did get, the procedural history, in many ways was largely known. So I would commend to your viewers, Yasmin, that they take a look at the memo that was filed with the affidavit, because it explains the rationale for why you keep this stuff under seal. You don't want witnesses to be threatened or retaliated against. You want to protect the safety of law enforcement officers. And we saw what happened in an FBI field office in Ohio. You want to abide the law. And Rule 6E of the Federal Rules of Criminal Procedure require that grand jury information and information derived from grand jury investigations be kept secret. You don't want to give a roadmap to people who might obstruct the investigation. And last but not least, you want to protect the privacy interests of individuals who may be mentioned in an affidavit but haven't done anything wrong. And so it's a very cogent, very thoughtful explanation by the government of why the most important part of this affidavit, the probable cause basis, remains redacted. Read it. It makes sense.
So let me read a part of it, Chuck, for folks, especially the part that you were just referring to, because I do think it's incredibly important. Talking about possible witness intimidation. Some information falls within more than one category. The categories described are information from a broad range of civilian witnesses who may be subject to witness intimidation or retaliation, information regarding investigative avenues and techniques that could provide a roadmap for potential ways to obstruct the investigation, information whose disclosure is prohibited under Rule 6E, which Chuck just mentioned, such as grand jury subpoenas, testimony, and related material. And then information whose disclosure could risk the safety of law enforcement personnel, which we have already seen after the search took place, and information whose disclosure could harm legitimate privacy interests of third parties. Shanmu, let me bring you into the conversation here and ask you that same question. What stood out to you?
Yeah, I think what really stands out to me is that the Justice Department didn't move any more quickly than it did. I mean, looking at this with my cap on as a former federal prosecutor, former counsel to an attorney general, just reading between the lines, looking at the headings, it's really alarming. I mean, this information was scattered across the resort area with really no security for it whatsoever. There's a big blacked out section of probable cause to believe that there was still on the premises remaining national defense information, classified information, despite what had already been turned over and despite what had been told to them. So that really paints a very alarming picture. Even without those details, they understood that there was good reason to believe that they weren't being told the truth from the Trump representatives. And secondly, the thing that just jumped out at me was the exposure for the Trump lawyers. If you look at the letter, the representations that they're making, I would be concerned if I were them.
It's interesting that you bring up why it took the Justice Department for so long. And I want to kind of draw on that just a little bit, Shannon, because I'm wondering if you feel as if the reason why they waited was giving a former president the opportunity to abide by the law, right, and return the information, the boxes, the classified documents on their own, instead of seeming as if, because that's what we've been hearing a lot about from the Department of Justice over and over again, and even from the current president, President Biden, in not politicizing this process.
Oh, absolutely. I think that's exactly right. I've been in meetings where people were thinking about the ramifications publicly of a criminal investigation, and these would have been really tough meetings. I mean, white-knuckle time, worried about how it might look. And of course, the mission of Attorney General Garland was to restore the integrity of the Justice Department after it had been debased by the Barr Justice Department. Ironically, though, sometimes you have to move more quickly and be able to take action at the risk of looking political to make sure that you're really protecting the institution. So that's really the tough place that this DOJ found itself in.
Charles, do you think it will hinder this investigation that is currently developing into the former president and the classified documents that were being held at Mar-A-Lago because they waited so long or too long?
Ultimately, I don't. I think that this investigation is not going to be impeded by what we've seen in terms of the delay in time, if you can call it that. The DOJ has been lining up their witnesses and getting together the things that they need for this investigation for quite some time. And so I think every effort was made and has been made by Merrick Garland to ensure that he does not in any way, shape, or form reveal anything that is going to make more difficult the task of his attorneys, his U.S. attorneys that are working under him, as well as the FBI who's working with him in this very historic and important investigation. But I did want to sort of point something out. I'm with Chuck in as much as I did not find a whole lot in the affidavit that I found to be incredibly striking, and that wasn't a surprise for me. But what I did find of interest, which was not contained in the affidavit, was the attached letter from Trump's attorneys to the DOJ. Right. And what I found interesting about that was this conversation where they lay out the notion of the president's ability to declassify documents, but they do not at any point state that the president actually declassified any particular documents. We all know as lawyers that if in fact you're going to play that card, you would then immediately follow it up by saying he has now declassified the certain XYZ documents, right, and identified what those documents are. They didn't do that in that letter, which completely undercuts the defense that they've been trying to assert from the start and the outset of this entire incident with the search warrant, which was, oh, well, these were documents which were declassified. That completely undercuts that defense, and I found that to be very interesting.
So, Chuck Rosenberg, I think what everybody's asking now is, what's next? What is the Department of Justice doing? What happens now?
Well, they sort of told you what they're doing, Yasmin. They just haven't told you how they're doing it. They have an ongoing investigation, which is why large portions of the affidavit have been redacted. They have numerous witnesses that they are talking to and protecting, which is completely appropriate. Remember, search warrants come at the beginning of investigations, or sort of the early middle, and not typically at the very end. So we don't know precisely what they're doing or how they're doing it, nor are we entitled to know that, but we know they're still doing it. And I wanted to point out, I think Charles made a really interesting and important point by noting what's missing from the attorney's letter. But there's something else I would add to that. The three statutes that the government relied upon to get the search warrant don't require that the information that's mishandled or destroyed or be classified information at all. So we can debate, all day if you'd like, Yasmin, whether or not the president can or did declassify information on his way out the door. It doesn't appear that he did, but it also doesn't matter. And the statute that Mr. Trump's lawyer cited in the letter to the government is an entirely different statute. It's not the one they relied on to get the search warrant. So Charles points out a really interesting flaw in the letter, but there are more. And I think the more we read it, the more we'll find.
But also, and to your point, it doesn't really matter, but how would you declassify a document that contains such sensitive information as to make vulnerable human intelligence sources overseas?
Well, you really can't unless you go through. You really can't unless you go through a significant process with the agency that generated the information and that has the equities in it. So, for instance, the government would, even hypothetically, Yasmin, if the former president was able to declassify everything, which I don't believe he can do, I think is fanciful. But even hypothetically, if he could, disclosing that information could still do great harm to the national security interests of the United States. You'd still need to do a damage assessment. So let's not get hung up on whether or not it's classified, because the statutes on which the government relied to execute the warrant don't require it. And moreover, there doesn't seem, to Charles's point, to be any evidence that he actually declassified the stuff. But in the end, it doesn't matter.
Shan, one last one to you, and it's this idea of intent, right? As we have spoken about the former president over and over again, really over the last 6 years, there is always this overarching question of, well, how do you prove his intent with whatever matter we're talking about, right? And I go back again to paragraph 24 in this affidavit, in which they refer to how this classified information was intermixed with newspapers and photos and personal notes. And I can imagine you got Trump attorneys and defense teams looking at that very paragraph and saying, well, he didn't know.
Well, I think to Chuck's point, he might theoretically be able to declassify information, but he can't transform national defense information into non-national defense information. And that's going to be a key part of the discussions in terms of what comes next at the Justice Department. There are going to be a lot of meetings where it is being discussed that exact point, which is what kind of intent here was there? Is there really a viable defense of innocuous or carelessness? That's what's really going to come next. This is going to be running up the chain. I'm sure Garland will be personally involved in this, as he already said he was, in terms of approving the warrant, as well as the Deputy Attorney General Lisa Monaco. At the highest levels, they're going to have to really debate this question of intent and decide, is it there or not? Is it chargeable?
Shan, Chuck, Charles, thanks for talking with me, guys. As always, I appreciate you weighing in on this. Thank you.